Okay, it's top of the hour, 6 o'clock. It's Winston Stevenson here with Winston and Company's Retirement and Financial Services. Boy, we got a big crowd on this webinar tonight, and I want to say I'm sorry for what happened at the noontime seminar. We lost internet right in the middle of the thing, and we lost. I think we had about 16 people on it at lunchtime, and so everybody, we went down, and I guess all you guys are back up on this call, so that's good, and hopefully we don't have any problems. So I see a lot of the same names that had given it a try this morning or this afternoon. I see Deb Holcomb on there and Larry, and so we're just going to go ahead and just jump on into this. So if you were on it today at noon, you probably saw a lot of this initial part, but let's just kind of get back on through it here, because this is a webinar about estate planning with a living trust. This is the 5th star, actually, over the airplane in our logo. It's income planning, it is investment planning, and it is, income planning, investment planning, kind of high-level tax planning. It's healthcare planning and legacy planning. Those are the 5 main core products and things that we do, services that we do here at Winston and Companies. So let's jump into this program about estate planning with a living trust. I'm going to tell the story again that I told this morning about what happens if you don't have proper estate planning done. So I want to start out with talking about understanding probate and the problem with probate. The problem with probate is that it's a process that is very time consuming. And when this slide was created, the process took minimum 6 months, typically more like 1 to 2 years. But since COVID-19 hit, these places are backed up. It's unimaginable. I don't know when they're ever going to get caught up. So it's literally more important now than ever to make sure you have your trust or estate planning in order, because they're talking about probate process taking 3+ years to get through the system because of all the backlog. All right. So one of the things that you have to understand about the problems with probate is an estate can have not just one, but multiple probates. A probate in each state where property is owned. So one of our clients, Daisy, and she's on the call here. Hi, Daisy. Daisy owns property here in Phoenix, but she also has a couple of homes over in California that are rental properties. And one of the things that came to fruition in our conversations is what happens to those properties should she die. And she met with Courtney, who many of you have met with Courtney, or she's our primary attorney here at Winston and Companies. And she works with Perkins & Zayed, the estate and trust law group. She works under Jennifer Seed, who is the licensed, she's the licensed attorney for Arizona, and Jennifer works under her. She's a member of the Illinois State Bar, but she handles our cases here in Arizona under Jennifer. So the bottom line is, Daisy met with Courtney, and I remember this. I remember this very clearly. Courtney said, "Do you know what it costs to probate one of these properties in Los Angeles County?" And Daisy said, "I don't know." And I was like, "Gee, I don't know either." And I was all ears. And it was over $22,000 to probate one property. So, when it was coming down to spending a couple $1,000s to set up, complete estate plan. I remember, Daisy, you probably remember too, when you said, "Yeah, that's a deal. Let's get this thing done," because not having it done can really leave a mess. Probate is required if the decedent owed more than $100,000, more than $100,000 of equity in real estate and personal property combined, or more than $75,000 of personal property, including all of their possessions and money. So, the bottom line is, this applies to a lot of people. Proper estate planning is not just for the rich, okay? Here at Winston and Companies, we handle this as a value added for our clients. We earn money in different ways here at Winston and Companies. One of the ways that we earn money is for fee-based planning, which is for things like this, the wills, the trust, the powers of attorney. We're allowed to charge, under our licenses, we're allowed to charge fees for services rendered. And this is kind of falls in that category where we work with P&Z, Perkins and Zayed, and that's part of the revenue stream here at our company. But it is a extremely valuable service that we provide. And our clients love it because they can come to Winston and Companies where it's a one-stop shop. Now, I want to make sure, can we talk to our people in the control room here to get on the chat screen, get up our link, okay? Because I want to reference this multiple times. If you're thinking that you need to come in and talk to us, I want to make it available through the chat room. So we'll watch for that to pop up here momentarily. But if you would like to schedule a time to come in and talk to us about this, I want to assure you one thing: that initial consultation with our attorney is absolutely zero cost, zero fee, zero obligation for our clients or our prospective clients. Okay, that's kind of the agreement that we have with this law firm. So again, keep an eye out for that message popping up. Understanding wills. Wills do not protect against probate. All right. The probate process it's called probate court, and the probate court is there to authenticate a will. So a lot of people may have a will. You could have written it out on a napkin, and they call that a holographic will, and it's legal here in Arizona. But what I don't want you to confuse is what's legal here in Arizona and how it really works in the real world. A will in Arizona is a guarantee of probate. I'll say it again. A will in Arizona is a guarantee of probate. Now, if you have family and you love your family, you don't want to put them through probate. So this is a grown-up thing to do. It's really a thing that needs to be taken care of. And so many of the clients and new clients that come in, I mean, we work with some pretty well-heeled people here at Winston and Companies. We work with doctors, we work with lawyers, high-income earners, but they were so busy at building their businesses, building their careers, they literally never had even a will. All through the years they raised their kids, or maybe they have a will, but it's really old. You know, they had it back when the kids were little, and now the kids are grown and out of the house. So it's really important that you understand that a will doesn't really get the job done very well here in Arizona. So I want to tell you a little story about Rich. The name shall be limited to Rich to preserve and protect the identity of the innocent here, okay? Rich came to us as a referral from his sister, Sandy, who has been a longtime client of ours for many years. And by the way, I want to thank all of you that were on last week's call for the referrals that you sent to us. We had quite a few referrals come in from last week's call, and I really want to thank you guys for doing that. You know, they say that a happy customer never sends a referral, but rather successful clients send referrals, okay? Successful clients send us referrals. So we want to thank you guys for that. Anyways, Rich came to us as a referral from his sister, Sandy. The backstory on Rich is he spent 32 years working for Boeing. And his later part of his career, he worked for Boeing out at Mesa Falcon Field, where they build the Apache attack helicopters for the Army. And Rich finally was about 68 years old, and Rich came to us in October as a referral. He decided to do business with our firm in November, and we rolled over his pension and his 401k from Boeing. Now, you could imagine, for a guy working at Boeing for 30 plus years, he had a sizable amount of money built up, well over $1 million. And so we endeavored to bring all the money over, and we put it in under management with TD Ameritrade, which is our custodian, TD Ameritrade Institutional. You know, there is a difference between TD Ameritrade Institutional and TD Ameritrade Retail. TD Ameritrade Retail is that guy with the black beard and the black glasses that you see. He's very folksy. He's very woke, right? Oh, we're going to do investing. Well, that's not us. We're an institutional investor, kind of play at a little bit of a different level. We're not day traders. We're here to build successful portfolios. So we brought in that account for Rich, And just another little sidebar, Perkins and Zayed, the estate and trust law group, is owned 50% by Dean Zayed, who is one of the partners with Mark Perkins. And Dean owns Brookstone Capital Management, which is our registered investment advisory firm who handles the investment platforms for our investors, okay? And that's how we got connected with P&Z, the estate and trust law group, because it's really a marriage made in heaven. You know, we're able to really work with our clients and share client information with the law firm because we already have that fiduciary relationship. So that's just a little cyber on how that works. Anyways, Rich brought all of his money. It took a while to transfer. So it was about middle of December. And all of Rich's accounts were brought over. We're now actively managing them. So he came in for one more interview in mid-December. And we said, hey, Rich, you know, now everything's over here. We've got your Social Security set to start in January. We're going to start sending you some money, some income in January. The only things we really need to do here is get your trust set up. You don't have a trust in place, nor do you have a will in place. We need to get that set up. We need to get some life insurance set up and long-term care set up. Those were the remaining three things we needed to do. So it was December. It's been a long year, the COVID stuff. It took a lot out of Rich to do all of this transfer, all this money over. And I can remember it like it was yesterday. We're standing in the lobby here in our office, and he said, let's just wait on that until January. He says, I'm burned out. We'll do it all. We'll get it all done in January. Well, I guess you could probably guess where the rest of the story's going. He never saw January. Rich passed away in his home, one of his two homes that he owned, on Christmas Day. And we learned about it, I think it was on January 3rd or 5th when we got back into the office this year. And it was a sad day. It really was a sad day because he never saw his first Social Security check. He never got a dime of all of that money that he built up. He passed away. And it was a real jolt. It was like a shock wave went through our office. We're like, oh my God, this guy that we just met, he trusted us. He was coming to us to build this retirement. He had a lot of dreams, a lot of desires, a lot of things that he wanted to do. And it just isn't going to happen. And it really made us realize, boy, people do die. All of us will die one day, and death is as much a part of life as birth. Okay. So while people talk about investments and they talk about insurance and they talk about this and they talk about that, there is no guarantee of tomorrow. And so if you have a will or a trust and it's outdated, you need to get it up to date. We can help you with that. Oh, by the way, if you look at the chat room to visit with us here at Winston & Companies, just simply click on the link and it will take you to our calendar page, okay? And you can schedule, a 15-minute Zoom call with us, a 15-minute phone call with us, or just say you want to come into the office and we'd be happy to have you come in and have a cup of coffee and a cold drink. It's getting kind of warm out. People are doing more cold drinks these days. But we are having people in the office, and we just want to make it very clear to you that we will observe the social distancing, wear a mask if you like. We'll wear a mask if you'd like us to. But, we do business the old-fashioned way. I really like to see people in person. So anyways, enough on that. But it really had a shockwave, and it made me, who, I'm in the process of selling a house and moving into a new house. And we had the current house in the trust, but we don't have the new house in the trust yet. And it just like, okay, I got to get a hold of Courtney. I got to get this stuff set up. So we're in the process of updating all of our own stuff because it was like a slap in the face. We had to get this done. And one thing that's really important that I want to share with you, Courtney said, Winston, what has Shane done for his estate planning? And I said, well, he's 25 years old. He doesn't have anything. He's new. He's starting out in the business. She says, well, it's really important that you understand that at 25, he's not your child anymore in the eyes of the law. Okay, he's still your child, always be your child. but he needs to get powers of attorney set up for healthcare directives, for financial directives, because if he was ever sick or injured, I can't speak on his behalf. My wife can't speak on his behalf under the law. So we're in the process of getting Shane powers of attorney set up because it's the right thing to do. And I'm going to recommend that you do the same. If you want to reach out and talk to us about it, again, click on that link in the chat and come in and see us, because it is vital. It's really vital stuff. So understanding wills. Rich did not have a will, not even a will. So the two houses that I mentioned that he owns, he died what's known as intestate. And intestate is like literally the bottom line. Here's a guy that's a millionaire. All right. Here's a guy that was very successful in his own right in his career. He had a lot of assets in these real estate, these two very nice homes out in the East Valley. Caught up intestate because there's not even a will to say who they belong to. So it's up to the courts to figure this out. You think that's going to get done in the next couple of weeks if you're his heirs? Well, because Rich owns those houses and there's mortgage on those houses, who's making the mortgage payment? I mean, this thing just gets dirtier and dirtier, okay? So I want you to be aware that you, like me, are living flesh and blood. You need to take care of this business. So oftentimes with our clients, this is one of the last things that we work on, but it really should be one of the first things we work on, okay? So this webinar is really important. Wills are fully public. There are, I call them creeps, but they hang out down at the courthouse looking to see who died. You know, they have a book and they're paging through it. Oh, who died? Who owes that guy money? Or who's that guy owe money to? And they just make a living chasing things down. Wills are a guarantee of probate. They're easily challenged by heirs. And so one of the things that someone on the webinar we had today at noon, we did take a call because I was talking about the black sheep. And it was a woman that was on the webinar that we don't know. She had been to one of our dinner seminars like 2 years ago. And she said she wants to come see us because I brought up this thing about the black sheep. And her and her husband have a daughter that is estranged. They haven't talked to her in over 10 years. And I told her about, in the conversation in the earlier webinar, you may remember I spoke about my own brother. I haven't talked to him in 5 years and my parents haven't either. It happens in families. All right. So, if you have kin that you're not dealing with and close to on a day-to-day, you're not alone. All right. This is not an unusual thing. But a lot of times a black sheep will come out of the woodwork after they learn of the passing of a parent and make a claim against the estate. You have to, if you want to protect the estate, you should do proper planning to take care of that. And wills don't hold up well across state lines. Like my parents are in New York State, my brother's in Nevada, I'm here in Arizona. And, if my brother were to make a claim against the estate, he could do it. But my parents, under my tutelage, if you will, they do have a properly set up living trust to which I am the successor trustee of. I'll talk about that word, successor trustee, here in just a moment. Okay, so it's important that you understand estate taxes. It's understanding probate is equally important. State taxes don't, and haven't for the last 6 years, really affected pretty much most people, okay? The very wealthy estate taxes are relevant to, but there's a concern that estate taxes may be coming back under the new Biden administration. We will see, okay? I'm from the government. I'm here to help. Sure you are, all right? So simple wills, bare bones living trust, they don't avoid estate taxes. Marital deductions are important because the spouse can inherit the estate free of estate taxes. But in order to have this estate tax conversation, your estate needs to exceed $11 million to be involved. So this doesn't affect a lot of people, but it may come around and start affecting more people again, like it did 10 years plus ago. Proper estate planning with a properly drafted and properly funded living trust is the key. Now, you can rest assured, working with us and Perkins and Zayed, that you are going to have a properly drafted trust. The last part, fully funded, is really up to you. And we help you do this, okay? Because we need to change account ownerships. We need to do all this stuff, get it into the name of the trust, deeds to property. Now, when we do a married person living trust, P&Z usually includes the cost of transferring one property. That's built into the cost. Additional properties cost more. But the properties are so important because they're so expensive. They become very valuable assets that go into probate, like Daisy's 2 houses over in LA County. You know, I saw the houses. You know, we looked them up on Google Earth. They were nothing to write home about. But Daisy will tell you, they're kind of regular houses down in the Compton area, okay? But the amount of money they were worth over $500,000 each because where they were, okay? So fully funding a trust is important. The reason they call a trust a living trust, so many people say, why do they call it a living trust? Well, living as opposed to testamentary, all right? So you set up a trust while you're alive as opposed to after you're dead, which is what a testamentary trust is. All right, we won't even get into the details of that because we're not talking about that. But a living trust is created while you are living, hence the name living trust. It is a legal entity that can operate indefinitely, and that's the key phrase. It operates indefinitely. We are flesh and blood. We are born, we live, we die. You establish a trust. The trust is like a box, like a hope chest that the carpenter builds. And in our case, the carpenter is the attorney. They build the box to take title and possession of the assets. So it's important that you, as the living flesh and blood person, transfer these assets that you own into the name of the trust. Now, listen to me carefully. Once you transfer the assets that you own into this box, this living trust, you don't own anything anymore. And while that might sound strange, that's a good thing, because if you don't own anything, there is nothing to probate. It's that simple. The assets, you grant them that you own, you grant them into this living trust, and they're in there, and you still have complete control of them because you are now the trustee or the boss of the trust. The boss of the trust is called the trustee. So you have complete control of them, just like you always did before you transferred into the trust. But upon your death, which is certain to come at some point, probably in the next 100 years, you're going to die. And then when you die, if you don't own anything, there's nothing to probate. All of the assets are in the trust. Okay. So one of the children of Rich called me up and he says, well, we want to get these houses up on the market for sale because no one's making the payment for it. So as an act of kindness, if you will, I referred them to Holly, who is our real estate agent. Holly spoke to them on the phone and she asked 2 simple questions. She said, do you own the house? And the children said, well, no, our deceased father owned the houses. And she said, okay. Second question, do you have the ability to sign documents and receive funds? Well, no. She says, I can't help you. We can't sell the houses, okay? So when you have a trust set up in the house, the property is in that trust. You as the trustee, while you're alive, you can do whatever you want with it, just like always. But upon your demise and you're gone, that property is in the trust. The successor trustee can liquidate or sell that property, can sign contracts as a successor trustee, can accept transfer of funds, okay? So upon death or incapacity, the trust goes on operating and based on the directions of the stated trust, disperses the assets in the trust to the beneficiaries in the trust according to the will, the new will that goes along with it. A living trust will avoid probate because it is a separate legal entity and it does not die. There's never a day of reckoning where it has to go into probate. So when you fund the trust owns the assets, not you. I know I'm being redundant, not you. So when you die broke, which is a good thing under the eyes of the law, okay? Funding is crucial. That's why you die broke, because you take the assets and you put them into the trust. The trust will be ineffective. It's more useless than yesterday's newspaper if you don't fund it. And we help our clients get it funded. Funding is retitling your assets in the name of your trust. So in my case, listen to this. In my case, I got a call because we put our house on the market, man. You know this, last Friday, we had 14 showings. Saturday, we sold the house, full asking price plus, and we're in escrow. So the title company calls me up and says, okay, we're getting ready to close here the 1st of May. Who are we making the funds payable to? And I said, well, I want you to make them payable to the trust, because the trust owns the house that was just sold. I get on my TD Ameritrade account, my joint account with my wife, and I'm looking at the thing, and it's in her name and my name with rights of survivorship. The trust is not mentioned anywhere. And I'm like, oh my God. So I got to fill out new paperwork to have the name of that account changed into the name of the trust. We're going to keep the account the same, but we have to get it transferred. And wouldn't you know it, I fill out the paperwork and I transposed a digit. I got my wife's social security number wrong. So I had to fill out a whole new form and get it done. And hopefully tomorrow that transfer is taking place. But it's really important. The details of this stuff are really important that you get this taken care of. It's not just for you, it's for me, it's for everybody, okay? Your trust does not have a list of the assets held in it. It's just the assets that you own should be titled in the name of the trust. And if the assets aren't retitled, they're going to go through probate because they will still be in your name. All right. Now, there is one little provision that we add called a pour over will into a trust. And the pour over will says that any assets that were acquired in the estate after the trust was put into place, it was the intent of the trustees to have had those assets placed into the name of the trust. So it kind of cleans up a little bit for you, but that's after the date or the inception of the trust. So the mechanics of a living trust are really important here, all right? The trustor is you, also known as the grantor. You create and you direct the transfer of funds and assets into the trust. The trustee manages the trust. That's why they're the boss of the trust. And the trustee is you. So in my case, I would sign paperwork, Winston Stevenson, comma, trustee. All right. The successor trustee would be my son, Shane. Okay. So if myself and my wife are gone, my son, Shane, is a successor trustee along with my daughter, Sarah. So they're co-successor trustees. They are also the beneficiaries, and they receive the benefits of the trust, principal, income, assets. A revocable living trust, which is what a living trust is, typically it's revocable without the use of the word, it's understood, but a revocable living trust can be changed by the trustees at any time. So if you set it up one way and something changes in your life, no big deal. You simply amend it, okay? And P&Z works with people that do that all the time. Now, you should consider a living trust if you own a home or if you own property. Simple as that. If you want to pass your estate with little expenses or delay. If Rich would have had a living trust, now we could have never gotten it done, so my conscience is clear there. We could have never really gotten it done between the middle of December and the date that he died, Christmas. It just wouldn't have happened. So again, my conscience is clear, but they wish at this point they would have had the trust in place because there's going to be no delay. Whereas now they're just caught up in, I don't know how long it's going to be. Could be years. You need a living trust if you want your affairs to be managed the way you direct them. If you're incapacitated, you want to eliminate or minimize estate taxes, or you want your affairs to remain private. That's a big deal for a lot of people to maintain that privacy. A living trust is equally important for a single person as it is for a married person. So single individuals have special estate planning needs because they don't have a legal partner to handle legal and medical affairs upon their incapacity. And they're just by themselves. So you need a legal document to designate who can make legal and medical decisions. Does that sound familiar? It's the same thing I said Courtney recommended that we get for Shane, my son. My daughter is 21, and actually she's still in school, but we got to get it done for her too. It just thought about that. All right. Joint trusts, typically for married couples, when you have an estate tax over when you have an estate over $11.5 million, we set up irrevocable trusts, that sort of things. However, these trusts divide into bypass trusts, marital trusts. I'll show you a flow of this here in a minute. Now, for high net worth people, you might want to talk about something called a dynasty trust. It leaves a lasting legacy for your descendants, all right, grandkids and that sort of thing. It provides funds for your descendants' needs. Descendants, not decedents. Shane pointed that out today. I said that wrong earlier today. Avoids estate tax across future generations and provides that your assets benefit your descendants. It insulates inherited assets from claims of your descendants' creditors. Interesting stuff, right? So, it's not for everybody, but it is for quite a few. Here's an example, this yellow oval. I don't like the green oval. I don't like the green oval just because it's an oval. It should be a box. But I didn't change it's harder to change these things than you think. Anyways, you're going to notice all this stuff, investments, residence, investment, all this stuff should be in the trust. Notice the arrows are flowing in. So we're using the example of Bob and Pat. Their trust has been funded by transferring their stuff, their property, into the trust. So Bob and Pat effectively, like I said before, they don't own anything. With their living trust in place, they will require literally no change in their lifestyle, no additional tax reporting or filing. Very simple. Once it's set up, it's really pretty good to go for quite a while. Bob and Pat's estate plan, because they have the trust set up, if they need money for something, it can come back out of the trust. There's instructions for disability. And when I mean disability, I mean long-term care, right? They're older, late in life, they need care in home care, assisted living, they need, chronic care, that sort of thing. Take care of us, take care of our family, take care of our obligations, okay? Your dues are never paid while you're alive, okay? Obligations must be met. So at Bob's death, the Smith Family Trust is in place and there's no probate. And it provides for Pat's needs. It provides a revocable and simple. When Bob dies, a revocable trust is very simple to administer, and it provides for a double step up in basis at the first death. This is something you might talk with your tax person about. But the bottom line is at Bob's death, it creates a survivor's trust for Pat. She's now the survivor. And at Pat's death, okay, we go from the survivor's trust down to the common trust. This is all layered into the trust that we do, all right? But you see those words, no probate, no probate, no probate. So that the common trust upon the death of the last survivor is designed to send money out to the beneficiaries according to the terms of the trust. We give you an example of a common term. When Susan is 25 or she completes college, that's when she gets her money. How about that black sheep thing that we talked about? If there's someone that you want to exclude, then what you do is you don't just exclude them because you don't mention their name. You absolutely mention their name, but you put something, I've seen this one done several times. Joey, who you want to have excluded, gets $1. This way, Joey can't come back and say, oh, I was overlooked. I was supposed to have gotten something. No, Joey, you got the $1 that was set up for you. Okay, this is where you can stay or remain in control of this thing. So the big deal is, you can have equal division, but you can also make that equal division amongst the people that you want to get it. So Smith Trust, upon the first death, flows down to the Survivors Trust. Upon the second death, it flows down to the Common Trust, and then is distributed out to whoever it is supposed to go to. In the Dynasty Trust, we can then have it even skip on down to John's Dynasty Trust, Peter's and Susan's Dynasty Trust, where each child can be a trustee of his or her share. These trust assets have significant protection from creditors. I kind of went through this before, but if a Dynasty Trust is something that kind of gets your attention, these trust assets at all future growth will never be subject to estate taxes. Again, kind of an important thing if you come from a very high net worth family. All right. So if that's something that you want to delve into deeper, if you go and you click on the chat room, be sure to mention that you want to talk about a Dynasty Trust. Okay. The other thing is that when evaluating Bob's and Pat's estate plan, their properly drafted trust will allow them to do the following. It'll help them plan for themselves, their children, and their future grandchildren. Okay. So if you don't have this stuff in place right now, I'm going to urge you to click on that link. We're seeing a couple people have done that already. Good choice. Click on that link and schedule a time to have a visit with us, a phone call or whatever. But, Daisy, I know you're still there. I want to just share a quick story with Daisy. Daisy came to us from a seminar that we did at Rio Salado Community College. It was actually a retirement planning workshop. We talked about trust. She is a highly compensated hematologist, okay, works in the medical field. She told me she had been trying to get a trust put together for 10 years, didn't she, Daisy? 10 years. And I'm like, how could you have been trying to do it for 10 years? She said, every place I went to start a trust was a trust mill. They were using a trust as a loss leader to try to sell me a bunch of stuff. And she says, I get started and they're asking about this or asking about that. Never got it done. Never got it done. And she said that was probably more than 10 tries over 10 years. And when she came to us, because we did her retirement income planning, we're doing her investment planning, we're doing some of her tax planning, okay? We did her Medicare planning. She says, can you take care of this? I told you about the conversation with the attorney about the probate costs in LA County. And we did it for her and it was done in 2 weeks. So one of our biggest advocates, okay? Control their property during their lives. You still maintain control of your property, even though you don't own it anymore. It's in the trust and you're the boss of the trust. It provides for disability. All right. One of the things that our attorney Courtney will say to you is, if you love your family so much that you want to go through the process of setting up a living trust, you really ought not to leave the back door of the trust open. And people will say, well, what do you mean by the back door? Well, if you consume all of the assets in your trust due to the expenses associated with a long-term care event, that's what we mean about providing for people during their disability. We're big advocates of long-term care insurance. So if you don't have your that's the single biggest underserved market is the long-term care market in an estate plan. So talk to us about that. Again, click on that link. Let us know what you'd like, what's on your mind. Give what they have to whom they want to give it to, the way they want to do it, the way you want to do it. That's what this is all about. Save tax dollars, court costs, magnificent savings of court costs, and attorney's fees. All right. You just pay a little bit up front to get the thing set up. You save yourself a ton on the back end. Hey, that is our main story on the living trust. I'm sticking to it. I want to invite you guys, give you one more offer to receive. I call it my book. I didn't write the book. Marty wrote the book. I wrote the foreword to the book. The book is called The No Compromise Retirement Plan. If you don't have this book, I have got a box of them sitting in the other room, and it needs to be in your hands, and you need to be reading it because it talks about the three main compromises in a retirement plan. And it really is universally applicable. Virtually everybody that read the book found great value in it. There's an awful lot of people that read the book before they ever were clients and they became clients. Click on the link in the chat room, ask us for your copy of the book. It's my gift to you for joining us on this webinar tonight. So, hey, thank you so much. I hope you guys have a great evening. It was my pleasure to host this. And we look forward to hearing from you guys soon. Looks like we've heard from quite a few of you. So again, have a great night. Thanks for joining us. I'm out. Have a good night. So let's see. I always got to struggle with how to turn this off. Stop the share and end the call.